So Deputy Attorney General Ababe Rubbish NPP legal vacation fight here just say guso fight here per se court no ebe sit on oral cases and as a trials and so Deputy Attorney General Nancy Kwajo upon Kroma issue Chief Justice on ne order judges ni be say sit on oral cases the likes of Kwabena Edubuain and Abdul Hanan. Lawyers no aba bekumbia be enne live on television. Deputy Attorney General aba shate Kwajo upon Kroma ne math app enne sa lawyers ya fight against legal vacation trials so Deputy Attorney General aka say oh no legal vacation no crampo enye ono kra no nim say emre bi na legal vacation cases no motina bi so na wombrem say during legal vacation no judges ebetumi atenase na omo the cases into ebusua or the omo atoto omo level me yenko na yenko ti Deputy Attorney General na nsema or the two dwa efa Atta Godfrey Dame ene Kwajo upon Kroma ni siwa ko siu Chief Justice HSA omo pese ye hot legal vacation trials no ye konkoti ye ba ye de aka beto am so abuzua on subscribe na hit on the notification bell so that any update we be drop no onso onsa ebetumi akabia ha Gossip Politics TV so and don't forget to click on the notification bell as well abuzua na Ghana ha say open computer papa and a laptop papa na we use Abura Perosi computers and accessories so and abenya laptop papa na we using the location enye Irakwan o Kumase Bokrom Estate Eli Frey number na egu e screen as no mo me bonra yen se me ba yede aka ebeto am
goes to Supreme Court to file that case, follows it up with an injunction, and on the face of the injunction simply says that Court 1 and 2 of the specialized division should not work. And you are wondering, why is he even saying Court 1 and 2 and not all the courts that are working during the vacation?
And for the purpose of my audience, this is Kojo upon Kroma.
Yes, Kojo
versus yourself as the Chief Justice in the matter of the debate around the legal vacation.
Exactly. So the concern of the plaintiff, Kojo upon Kroma, is that the CJ's warrant for judges to sit and conduct cases over the vacation is unconstitutional. That's the substance of his case. There are about almost 30 judges or 30 courts sitting. So why single out only 2? And I think that is as a result of bad faith. You see, you don't use the law or the legal process to achieve another purpose than what it's designed for. So the fact that you have chosen even 2 instead of all the courts that are working with the warrant tells me that you have an, I won't call it ulterior motive, but you have an auxiliary purpose that you want to achieve, but you are just using the court process to achieve that. And that result has been achieved in the sense that by merely filing this, of course, the judge has agreed that he has to hold on pending the decision in the injunction application. What it means is that tomorrow, another person can file any suit in the Supreme Court and file an application for an injunction, and the court would have to stay its proceedings pending the determination of that as well. And if that is allowed, what it means is that we can have the whole vacation. The court, this particular court, will not do its work because some unrelated parties are filing suits in the Supreme Court. And our argument was simple that this is even a different situation because if the person was a party to the case and he has raised an issue with any part of the proceedings, and he has gone to the Supreme Court to seek a certiorari to quash it, we can understand why a judge would say that, well, I will abide the decision of the court. But this is completely, in fact, this court is not part of the case, is not sued. It is the Chief Justice's warrant, which is an issue. So, but of course, when the court decides, we have to wait. So we are waiting for the Supreme Court to decide the injunction. We just hope that another person will not go and file another suit and still name these courts and say that they are seeking injunction on them next week. And then the court will say, based on the same principle that I stood this week, next week too, I will not be able to work until. We just hope that that doesn't happen. But this is the foundation for that to happen.
But you see the court's point in this matter. I mean, the Supreme Court is, is the apex court. If they're going to decide on whether or not he can sit, because that's basically is the decision the Supreme Court will have to render. He just have to wait. I mean, a few more days. It makes sense, does it not? That just simply to wait.
Like I said, the decision of the judge is not out of the law. It is within law, right? But it's also policy-based in the sense that tomorrow, that's the danger in these things. That is why if you were in the court, you realize that I cited about 4 or 5 cases where the court said that when public authorities are performing their function, it is not a private issue. So the courts distinguish between 2 private persons fighting in court and one getting an injunction, from where the public authority is working for the general good of the country, and then one person goes to court to say that I disagree with this, and then the person applies for injunction and expect that the whole public, what is being done for the whole public, should stop pending the decision of the court. So the courts have consistently held a view that this is not applicable, this principle is not applicable when it comes to public law matters, because the public law matters affect the whole country. So one person cannot come and say he's filing an injunction and then the whole public have to wait. Even in the recent case of against the District Assembly Common Fund, the same principle was established again. So the courts always draw a line between private matters and then public law matters. And in public law matters, the position has been that an application for an injunction does not stop a public office or public official from functioning pending the determination of the injunction itself.
How confident are you that the Supreme Court will render a verdict that, in essence, agrees with your fundamental position that the CJ was within its right, legally, procedurally, all the other rules that govern the court to set up the courts to hear these cases?
Yeah, so this is the thing. The challenge is, the plaintiffs or GBA and the other persons, what they are saying is that the Chief Justice doesn't have the power to issue warrants for judges to sit. And in making that case, and I think they also know that position is not tenable. So they color the conversation or their concern by saying that it is selective justice. And then they threw in an allegation that the Chief Justice gave a warrant to the judges to hear specific cases, which suggests that the Chief Justice identified some cases and said, when it comes to this particular case,
the Addo,
and they said that when it comes to these cases, do hearing. But that is not what the warrant says. And I think your station has
we saw that warrant that broadly said hearings. For hearings.
So it is not true. So there's a bit of untruth in there, and it's also repeated on their rates that selected cases or special criminal cases, but there's nothing like that in the warrant. I am looking forward to the Supreme Court making a pronouncement, and I'm also looking forward to them to show how they came to the conclusion that the Chief Justice selected some cases and asked the judges to hear that. And you see, when we do some of these things, even as lawyers, okay, when lawyers speak, the public trusts that what they are saying is true. And that is why most of the times the people take the word of a lawyer very seriously. So when a lawyer comes out to make an allegation as serious as this against the Chief Justice, saying that he has selected some cases and are giving them to some selected judges to continue hearing, when indeed that is not the case, it disturbs the public trust in not just the lawyers, but also the judiciary. And so I find it quite strange that this is being championed by lawyers. Now, when it comes to legal vacation, I've already said that it is only for judges in the Superior Court to go on vacation. And it has always been the tradition that even during legal vacation, they select vacation judges who sit and hear matters. Now, there's this argument that vacation judges only hear motions and not conduct proper hearings or trial.
Well, the GBA says they never hear trials.
Which is completely false. Because this is how it works. A vacation judge is also a judge who is entitled to his vacation. So when he works in the vacation, what he does is that just as the courts come back, then he proceeds on his vacation. Now, if you follow this alleged interpretation or understanding of the GBA, you would notice that is not, it cannot even be workable. It's not even workable, that's it, because if you are a judge, you have your own cases. A vacation judge does his own cases, okay? He runs his own court. Then in addition to that, the Chief Justice assign other cases from other courts, other courts' cases to him. So I'm vacation court judge sitting in court A. Because there are other matters that may be urgent in court B, C, and D, the Chief Justice often attaches other courts to vacation court A. It is only when those other cases come that the vacation judge will not hear the merits and will conduct only the motions and the urgent matters. But when it comes to his own court, he hears not just the motion, but he hears the merits of the case because he knows that he will also be going on vacation. So if you apply the GBA interpretation, what it means is that then this judge will not be able to hear any case until January next year. Because then when the others come, he goes on vacation and another judge cannot hear his cases. So it's bizarre. And I think for now, there's ample evidence, even from the media. Journalists have been able to pull out several cases, instances where courts have conducted trial, superior courts have conducted trial during the legal vacation. So one of our attorneys just, we're going through our files, they reminded us that even the Takoradi girls case said it was conducted during the legal vacation. I didn't even know. It was conducted during the legal vacation, even amid protests from defense counsel. So it is also not true that before a judge will conduct a case during the vacation, the lawyers must agree. What it means is that now lawyers are deciding how cases should be conducted, which is never the essence of establishing a judiciary. Because for every case, one party wants it fast, while the other wants it slow. Because the interests of lawyers never merge. That is why we need a judge to balance the interests and give us where justice will be.
And you want this fast?
I want it fast. And I want it fast because the constitution demands that we conduct trials fast, quickly, speedily. It's a constitutional provision. Article 19(1) says that every accused person is entitled to fair and speedy trial, and that trial should not be delayed. And I believe that it is also in the interest of the accused person, whatever allegation is put on you, to quickly have it determined whichever way, one way or the other, so you know your fate. But I'm also a legal practitioner and I've done private practice before. And I know why in criminal matters or even in civil matters, one lawyer would say that I want it slow.
Why? Because
evidence is fungible. Evidence is fungible. So as you proceed slowly, witnesses may die, so many things can happen. So the delay may be beneficial to an accused person because the standard of proving that someone is guilty is very high. And you are relying on evidence, documents, electronic evidence, and all that. And all those things are fungible. They may deteriorate with time. Memories may fade. So there is a good reason why, an accused person and his lawyer will want a trial to slow.
But the accusation against you is that you want it fast to serve a particular partisan end, which is to appease the rank and file of the NDC, because you made promises to them that you will prosecute appointees of the previous administration and jail them. And these two cases, Dubahin and the case of Hanan, are jewels in that crown that you need to deliver to your base. And that's why you want this quickly, and not because of a constitutional requirement.
There are two answers to that. Two things can coincide. Okay, so the interest of my political party, the NDC, can be equal to the interest of the Constitution. And in this case, I've demonstrated that the Constitution is mandatory that we have speedy trial. So the NDC's interest in this case seem to align with the constitutional demand. So there's nothing wrong about that.
Except that they say they are perverting the course of justice to achieve that end.
That is exactly where we need the evidence. Because if you say by being fast alone doesn't mean that you are perverting the course of justice.
As in manipulating legal vacation to expedite the process.
Yes, that allegation is what we are expecting that they will prove, because whatever the Chief Justice has done, at least the evidence shows that it is the standard practice for decades, for so many years in this country, that during vacation, judges sit, vacation courts are appointed. And let me also add this. The impression which the GBA and the council on the defense council also are creating is that the courts are only conducting trial in these particular oral cases. And that is also false. There are oral cases before some judges who are not vacation judges. Those cases are not moving because the judges in those cases are on vacation. So if it were something that we are trying to manipulate and we have the power to do, then it's possible, then I don't see why we should allow other cases like SCB and others to go on vacation.
Is the NSS case being heard during vacation?
No. So you see, it is not true that we are designing so that oral cases move. There are other oral cases that have not been part of any legal vacation. The judges are on vacation. Untumi's Exim Bank is before a different judge. The judge is on vacation. We can't do anything until she comes back. The Nimre Forest case is before a different judge. So there are oral cases that are not being heard in any court because those judges are on vacation. And again, it is not also true that these judges are hearing only oral cases. Every case in their court are being heard. So if you take the specialized court,
Achibonga's court.
Achibonga is the one hearing the OSP. OSP has some cases before him. And those cases are also being heard. Those are not oral cases. And there are other cases that they are trying which are not being heard in other criminal courts and other courts, and across the country. So I see it as a propaganda to get a certain result, which is that let's interfere with the process so that we do not have so that we delay the trial. And because these lawyers know that these vacation judges will go on vacation in October when the others come. And the same argument will be that, well, if you're on vacation, you cannot conduct trial. So by succeeding in preventing these vacation hearings, what they have done is that they have securely adjourned all these cases to what? January 2027. That is the effect of it. And I don't think that's what the Constitution intends. So if anybody is manipulating the rules of courts and the judicial system to pervert the course of justice, definitely will not be the Attorney General who is conducting trials in accordance with law and practice of the court, but the one who is trying to change the practice to suit, their interests. Mm-hmm. And I think the public, I'm happy because when I see the public response from your media and your website, and I think the public understand clearly that this is strange because the public, they live this life and they know that during vacations, cases have been heard and decided. Trials have been held during vacations. So they are actually surprised that all of a sudden there's an argument that cases cannot be heard. And I'm happy. And that sets my heart at rest, because then I know the people I'm serving know that this is the place of the law and that I am not doing anything. My boss is not doing anything, and President Mahama is not doing anything to pay the cost of justice, but just allow in the system.
Ultimately, the Supreme Court must agree with you. You're confident, based on the case you put before them, that they will?
I believe the Supreme Court would uphold the practice, which is that vacation judges should be allowed to do their work as they have always been doing, and that there's no rule of practice or any tradition which allows lawyers to determine the pace of the court. I mean, this case, as you said, I want it to continue. Counsel on the other side doesn't want it to continue. So there's a conflict at the bar. Why do we have judges? To resolve that conflict. And so it cannot be that the courts expect that lawyers will sit in their chambers and decide that they will not come to court because it's legal vacation. And by that, then their position holds. It doesn't work that way anywhere. And let me just add to this. And this is in respect of the Addo case. And at the end of this explanation, it should be clear to you what the goal is about all this legal vacation. So, as far as the Addo case is concerned, our last witness has been in the box for how many weeks? Almost 6 or 7 weeks of cross-examination, which is extremely long. the judge has had the occasion to caution counsel that if you don't end this your cross-examination, I'm going to compel you to end because it's been overly long. Now, by negotiation at the bar as usual, the judge gave counsel 4 days. That was before the legal vacation. Defense counsel has used 3 of those 4 days. The only thing left is 1 more day for him to finish. And when he completes, what's going to happen is that the court will adjourn and give them 2 weeks, minimum of 2 weeks to file their submission of no case because we have closed our case. That doesn't require you to come to court at all. After the 2 weeks, when we are served, we're also given a period of time, usually 2 weeks or more, to also respond to their submission of no case. That also doesn't require that anybody comes to court. That's 1 month already. That's even if the judge takes the minimum period. That's 1 month. So August would have been gone without anyone coming to court. Now, after that, the judge will adjourn to consider our various submissions. Usually we'll give a week or 2. That takes us to middle of what? September. Then the judge will come and give a decision, a ruling on the submission of no case. If the judge upholds the submission of no case, that ends the case. The accused person is happy and is gone home and the case is over. So if it's about good faith, I believe that as a defense counsel, we should be interested in how soon this will end so that we even have more space next legal year. But that is not the case. Now, let me take the other side. If the court holds that the submission of, dismisses the submission of no case and directs the accused person to open their defense, this is what's going to happen. The judge is bound to give the accused person 3 weeks to file their defense. That takes us into what? October. Still, this doesn't require you to come to court to do any business. Then, after you file your defense, that's witness statement for your witnesses, then the court will set another day for what we call case management conference, which is usually another 1 week. So even with this Addo case, if the court is allowed to proceed as it's supposed to, there will be only 1 day in the legal vacation that there will be any court proceedings. The rest will just be filing, ruling, counter filing up to like November. So if counsel is telling me that he has booked so many things and that he's so busy that he can't do 1 more day, and yet is filing other cases in other courts, it tells you what is at play here. And it's not, it is not a question of legal vacation or not. It is a defense strategy. Whether for good or bad, that I leave that to the listeners.
But basically, you say defense strategy to delay the case.
That is my candid opinion on this. Because I don't see why 1 day of cross-examination should be dragging us into this. Especially when you are in other courts, working and filing processes.
And Thursday, the Supreme Court will decide this and put some finality to the matter. Let's deal with some other oral cases. And before.
So, Deputy Attorney General and I saying Kase Odessa and Semino to the legal vacation or my full update yede a honsem at the Brem. We better must say some penny Coco Tisa and some way at my gossip politics TV. So.